Now, my guest, Rachel Litchman, who is back, criminal defense lawyer with Litchman Law. We had such a wonderful conversation at the time of sentencing hearing. Have you in, Rachel, on what is a very big day? And I just want to mention, yes, of course, we'll talk about McArthur, but we're also watching Quebec City together. Alexandre Bissonnette being sentenced for the killings of 6 men in the Quebec City mosque just over 2 years ago. And his case, asking the Crown is for 150 years before eligible for parole. This moment of sentencing, it is one of the moments in the course of a court proceeding, isn't it?
Definitely. Especially with Bissonnette, if he gets 150 years, that's going to be the highest sentence in Canada. So far, the highest we've seen is the 75 without parole. One of those was in Ontario with the Millard case. So if Bissonnette does get that 150, that's setting a really high bar.
Okay, so many things to talk about on this pivotal day. One thing is, I want everyone to understand the terminology. In both cases, we're dealing with mass killing, serial killer, mass killer. 8 counts of first-degree murder, 6 counts of murder in Bissonnette's case. We don't talk about 8 life sentences. We don't talk about 6 life sentences. We talk about 1 life sentence, because one only has 1 life to serve, but with no eligibility for parole, right?
That's correct.
Just help us understand the exact understanding.
So as you said, it's just 1 life sentence,
right,
because each person only has 1 life. But it used to be before 2011 that you could only get up to 25 years without parole. It could not go past that, meaning that you had a chance to apply for parole at 25 years, not meaning you would automatically get that 25 years and you'd be out, but you had that opportunity. Now, since 2011, the law has changed, and it's allowed to stack the paroles, right? So if there's multiple murders, we're now allowed to say, okay, it's not just the 25 years, but it's 75, 150, however many the Crown is asking for.
So we have, in this case, in McArthur, 50 years, and in Bissonnette, 150 years.
Exactly.
In 2011, it was the Harper government that changed that law as part of its law and order agenda, and there are people who don't like it. They call it Canada's new death penalty. Why?
Because, in essence, what that sentence will do is that person will die in jail then. If they get, if in the Bissonnette case, he's sentenced for a life in prison without a chance for parole for 150 years, well, then he's literally sentenced to die in prison, right? But it has been challenged in the courts, specifically in Toronto courts, as to whether it's constitutional, as to whether this new section should be allowed, whether it's cruel and unusual punishment, whether...
As Bissonnette's lawyers have in fact said it would be.
Exactly, and it's coming back today to see what the judge there in Quebec is going to say about it. But in Toronto, we've already had rulings about that exact issue. In 2017, there's a reported decision from Justice Campbell where he says it's not cruel and unusual punishment for 2 reasons. Number one, it's in the discretion of the judge to choose whether they use that or not. They don't have to, as we see with McArthur. Both sides are making arguments for why or why not it should be used. But also, Justice Campbell was saying that there needs to be something to show proportionality, to show that someone who commits first-degree murder against one person doesn't have the same amount of moral culpability as someone who, if in Bissonnette goes and commits a mass murder, or someone like McArthur who's, targeted vulnerable people one after the other for many years.
Okay, you said a very important word, proportionality. We should listen to that in what the judges say in their sentences today. That's one of the factors that they'll look at. But when we talk about, potentially 150 years, 50 years, I mean, this is a stunning fact, but the Guinness World Record, there is a man serving a 30,000-year sentence. I mean, which is extraordinary. But we have, for example, in the United States, the movie theater shooter sentenced to more than 3,000 years. I mean, these are absurd lengths of time, obviously not in any way, shape, or form able to be served.
Right.
So, but is Canada moving toward this sort of U.S.-style punishment? Would today then be a turning point?
I think we're really not there yet to say that we're like the U.S.
It's obviously very far from that. But
yes. First of all, in the U.S., they do still have capital punishment, right? So that already makes it completely different than what we're dealing with here. And I think that, first of all, in the case here with McArthur, the Crown could have technically asked for the consecutive sentence for 6 murders, right?
Okay.
They've only asked for 2 because they're not saying we're just going to ask for something that's ridiculous, like you're saying how it is in the States, this 3,000-year sentence. What does that even mean, right? Nobody lives anywhere close to that. But the Crown is saying, no, we want those 2 sentences because we don't want the families of these victims to ever have to come and have to testify again, right? Because there is a chance, a slight chance, that McArthur could still be alive at 91 years old, right? But if they do the 2 sentences, and the 2 parole.
Right, periods
so
of 50
parole.
years before eligible to ask.
Exactly. Then there's no chance that he's going to be alive when his sentence is over. And then again, there's no chance that the families have to come forward and testify again.
So that's a really interesting thing, because we know in the Paul Bernardo case, the murders of Kristen French and Leslie Mahaffey, the families had to face him not that long ago for his first parole hearing, and it was devastating to them as they testified. They want to avoid that in the cases of that we're talking about here. Elizabeth Wettlaufer, 8 convictions. Again, a serial killer. They, in her case, Crown and defense, agreed on 25 years before she can ask for parole, even though she had 8 convictions.
Right.
Because, in part, they agreed because she had pleaded guilty, it saved the expense, the time, the anguish for families of having to go through a trial.
Right.
That's what Bruce McArthur did.
Exactly.
So that will be a factor, do you think, perhaps weighing into
things?
I
mean, it's the only factor, really, that the defense can rely on because everything else is so egregious, right? It's the only thing that goes to McArthur's credit. It's the only factor that's on his side, and it was the bulk of what the submissions were from his lawyer, right? So, yes, it has to be taken into account. It always has to be taken into account, but then there's so many other things that need to be weighed, right?
Right.
So the judge has to look at everything. And I think it's also interesting that it's only 3 out of 10 first applications for parole get granted, right? So, I mean, in a way, it's even more upsetting to the family, right? Because they have to be there, they have to relive it, and then there's such a small chance that that person is going to get what they're requesting. So it's almost like, why are you dragging us out here and making us go through this process and this formality when no one's getting anything out of it?
Extending the anguish and reopening all of having to relive all of that history. There are so many more questions, so much of interest in what we're going to be watching unfolding in these 2 courtrooms today. Would you stay with me and come back in the next hour as we get set for the 10 o'clock sentencing? We'll have more of a discussion then. Is that okay?
Of course.
Sounds good. Rachel Litchman here in studio with me. Again, extensive coverage of the sentencing of Alexandre Bissonnette and of Bruce McArthur. You're watching special coverage of that on CBC News Network.